This course is based on a professional approach. Pretty much it's aimed at showing you how to spot landmines before you step on them or before your boss steps on them. It's kind of hard to get that gold watch at retirement if you let your boss walk into a suit of some kind. And even worse if you let your boss lose. It'll teach you how to assert your rights to particular things, and it'll also give you the valuable information about knowing when to shut up and back away. That's an important thing. Lectures, of course, will be on YouTube. I'll send you the URLs through email, through Polylearn. Grades are based on the exams. We will have 3 exams. Grades are also based upon blogs, but not in the sense of getting extra credit. Blogs are a part of the expectation for the course. If you don't blog, you can lose points. You don't get any additions for them. Essay exams will come at the end of the first week, third, and fifth week. That may not occur. We may not have the first exam until sometime in the second week. I'll always give you a day or two to send me blogs with questions about the materials we've covered, and that way you will be prepared. The exams are built around hypotheticals, and the hypotheticals are drawn from real-life lawsuits. And the key in this course is figuring out what the legal issue is. And in order to do that, you need to read the textbook, watch the lectures, read the textbook again, blog, and then watch the weekly blog responses. I will put together a video with the blog questions that you have or comments and post them on Fridays. The legal issue? Well, you need to learn how to spot that, because in life you don't know that there's a legal issue until you get sued or until you get arrested, whatever it is. So you have to be able to spot the ways you can get into trouble. And of course, trouble can mean being arrested, being sued, having your publication subjected to a prior restraint. So here's a sample question, and I know it's going to be difficult, but bear with me. This is a sample question that I've used for law classes in the past. And here you can read about Judge Jameson. He's a judge in Oklahoma, the city of Norman, and for those of you interested in collegiate sports, of course, that's where the University of Oklahoma is located, a place I used to teach at. And here we have, there was a story published in our hypothetical in May of this year. Now, I've set this in Oklahoma, but for purposes of our discussion, the state that I picked has no impact on what's going to happen. So here's the story that was published. We see the headline, Judge's Truck Seized. And we get to see the story. It's a fairly short story, but the gist of it is that agents in Oklahoma made a drug arrest, and they seized a pickup truck registered to Judge Jameson. There were arrests. They took 500 pounds of marijuana. They got firearms. And specifically, they found the marijuana in a camper shell on the back of the pickup truck that is registered to Judge Jameson. Of course, this is unusual because Jameson has a record of giving really hard sentences in drug cases. Now, he couldn't be reached for comment before the paper published the story, even though the paper and the reporter made numerous calls and sent several emails. After the publication, Judge Jameson comes to see you because he knows you're enrolled in this class, and he tells you these things. Number one, he sold his pickup truck on May 12th to Andrew Dice. He had advertised it only in the classified advertising section of Bob's List, and Dice, notice there's a different spelling of Dice's name. He uses a lot of aliases. So Dice responded to the advertisement. Jameson has printed out a copy of the ad. He has a copy of the bill of sale. And Judge Jameson says, well, it must be that Dice never registered the truck under his own name. And, of course, the judge says he's never been involved in anything illegal. You also know the reporter, and she tells you that she went to the state motor vehicle records to trace the ownership. but because the judge is making threatening noises about suing, she doesn't tell you anything else. So here are the questions you would typically see at the end of a fact pattern. What lawsuits, who's going to win, and why. You always need to show your work. And what this means is this is kind of like math exams and quadratic equations. You have to show every step. If you don't show every step, you can't get credit. Also, it can be helpful when you go through a case and when you look at the issue and the rules, you may think that you can dispose of the case on a preliminary issue. Even if you think the case is over, based upon one of the first rules to be applied, you need to go through the whole set of rules, because you could be wrong. And if you're wrong with that initial conclusion, when you put down the rest, you have the chance of saving your grade. And of course, you cannot create any additional facts. We don't let you interview Mr. Dice. We don't have any videos of what's going on. You have to deal with the hypothetical on its own. When you're looking at these things, I recommend using IRAC. IRAC is a system that's used in the law schools for figuring out what's going on. And the I is the issue. Simply put, what is the tort? Tort, of course, from French, it talks about a civil wrong. R is for the rule. What's the rule? Each tort has its own set of rules. The A is the application. How do we apply the rules to the facts? And of course, C is the conclusion, who wins and loses. The conclusion is worth the least number of points, maybe 2. For you, the issue is the most important thing to get right. Students who, in the in-class version, who don't do the readings before lectures, who don't pay a lot of attention, will often see a familiar word when they've skimmed the book, and on an exam they'll assume they have spotted the issue. And students will proceed to write really amazing, incredible answers, but they're to questions that are not on the test, and then they wind up with 0 points, unless they get the conclusion correct and they get 2 points, but that's it. Here, based upon these facts, we have a libel case, and we also have a false light invasion of privacy case. Both libel and false light are torts, civil wrongs. We know that when we take a look at the Liebeck versus McDonald's case, it's a matter of somebody causing somebody else to be harmed, and then the victim of that harm sues in court for compensation. In the law, we call it being restored to the position they held before the tort occurred. And we'll get into the Liebeck case shortly, so just kind of hang in there. Libel. All right, we've spotted the libel issue. Now let's look at the rules. In order for a libel plaintiff to win a libel case, the plaintiff has to prove 5 things. I call them the 5 fingers of libel. Number 1, there has to be publication. Someone has to see, hear the offending statement. 2, identification. The plaintiff must be identified in the publication. 3, defamation. Now, libel, defamation are usually interchangeable in ordinary conversation. Here we're using defamation as a term of legal art. And our definition of defamation is, number 1, the damaging statement must be wrong or false. It also has to harm the reputation of the plaintiff. But if it's true and it harms the reputation of the plaintiff, well, that's just too bad. The 4th finger, damages, we'll leave that up to the forensic accountants and the lawyers. And then 5, fault. The First Amendment requires that a plaintiff prove that the publisher defendant was in fact at fault in publishing the offending statement. Libel plaintiffs have to prove all 5 fingers. 4 fingers, you don't get the money. So applying the rule to the facts of our case, we know it was published. People saw the story. We've satisfied the 1st finger. 2nd, identification. The story has named the judge, second finger's there. The third finger, defamation. Was the story false or wrong? Well, the story was true. The story said the truck was registered to the judge, and it was registered to him. He sold the truck to Dice, but Dice didn't change the registration, so the registration at the DMV shows that Judge Jameson is the registered owner of the truck. That's the truth. So our plaintiff, Judge Jameson, has failed to meet the third finger. His case isn't going anywhere, but let's go through the rest. Damages, of course, we'll leave that to the lawyers. Don't worry about that here. But then we come to fault. Fault, it can be explained as the thumb. It's the really opposable digit that makes us be able to hang on to the check. And we have two kinds of fault that two different types of plaintiffs must prove. Now, the first is for regular, ordinary people. People like you, people like your classmates, maybe your parents, just the ordinary Joes. Ordinary people only need to prove that the statement was published negligently. So, negligence is defined one of two ways. Either one gets you to negligence. The first is a failure to do something that a reasonably prudent person would have done. A reasonably prudent person would have done X. You failed to do that. You were negligent. Or it is doing something that a reasonably prudent person would not have done. So you did X, but no reasonably prudent person would do X. You were negligent. And for purposes of this class and your professional lives, negligence is pretty easy to prove. If you get it wrong, you're negligent. And let me explain what I mean. The truth was out there. You failed to find the truth. Therefore, you published something that was false. When we go to trial, the jury will hear what the truth was. The jury will know who held the truth, who you could have contacted, and the jury will see that you failed to contact that source, or you chose to ignore the source, but you got it wrong. See, the jury is looking at the case a couple of years after the fact, and they have 20/20 hindsight. And when they're sitting there in the jury box, they're thinking, no, I would not have gotten it wrong. I would have checked this one source. I would have double-checked the information that I had. The fact that you didn't and got it wrong is proof that you were negligent. So try not to get sued by ordinary folks or famous people. Famous people and public officials have to prove that the statement was published with actual malice. So Beyonce, Donald Trump, Joe Biden, right, they have to prove actual malice. Beyonce because she's famous, Donald Trump because he's famous and is running for public office, and Joe Biden because he is a public official. He has, in this case, fame or notoriety. He's been elected and re-elected. He's a public official. And so he has to prove that level of fault before he could prevail in a libel case. Now, when you see actual malice, it doesn't mean that you're being mean or hateful. It's a term of art. And actual malice means one of two things. It means that the publisher published the story either knowing it was false and published it anyway, or the publisher published the story with reckless disregard as to the probable falsity of the statement. It's a lot to wrap your head around. And we'll spend a lot more time talking about that as we move through the class. So, reckless disregard, because knowledge of falsity, we don't have a lot of cases. Knowledge of falsity, Darwin has taken care of the publisher before that person can get into a position of authority. But reckless disregard, well, it means the publisher published the story, even though objectively speaking, it should have been clear that the story likely was false. Now, it's hard to prove actual malice, much harder than negligence. So it makes it harder for famous people or elected officials to win libel suits, but they do from time to time. So our conclusion, remember we've spotted the issue. It's a libel case and a privacy false light case. We've looked at the rule, the 5 fingers of libel. We've applied the facts to the 5 fingers, and we see that the middle finger isn't there, and we haven't gone through an extensive analysis of fault, but based upon the facts, you could conclude that actual malice wasn't present. So the judge would lose. That's your conclusion. He loses because of these 2 things. It's complicated. The more we do, the more comfortable you will be. Let's move on to the second tort, false light. It's a privacy tort. It belongs to that category of civil wrongs that arise from the notion that we have the right to be left alone. False light is about lying about somebody to the public, not leaving them alone, but putting their name out before the public associated with a lie. In false light, the plaintiff has to prove 4 fingers. The first finger is publication and identification. False light, we just kind of put those 2 together. So you have to have a publication that other people see. It has to identify the plaintiff. Falsity, the second finger, it must be wrong. False. The third finger is offensiveness. The falsity must be offensive. Now, when we're talking about false light, we can simply say that the jury will find it offensive to have somebody lied about. So the publisher lied about you. We think that lie, that falsity, is offensive. Fault, instead of negligence and actual malice, false light requires that every plaintiff prove actual malice. If they're ordinary folks or famous people or elected officials, they all have to prove actual malice. So here, the first finger is satisfied. There was publication and identification. Second finger, the story was not a lie. It was true. There's no falsity here, so the case is over. But you have to go through the remaining elements of the rule because you could get it wrong. And I need to know that you know all the ways that you would win or lose. Offensiveness, the story is true. There can be no offensiveness. Fault, there's no way for the judge to be able to prove that the story was published with actual malice, certainly not knowledge of falsity, and also no reckless disregard. So it is complicated. The judge loses the libel, the judge loses the false light case, but IRAC breaks it down. It gives you, once you spot the issue, the rule. You can then walk through the facts of the case, apply the rule to the facts, and come to your conclusion. So work with me. Ask questions through your blogs, your emails. I will post questions and comments as the term goes along. And of course, before the exam, you'll have a day or 2 in which to pose all your questions, and I will make another video on YouTube for you to see. Take a little break. And here we are back again. Media and the law. Of course, we can be arrested and prosecuted for violating a law. We might even be convicted. And if we're convicted, we could be fined or jailed. Pretty much that's all we can do. We can also be sued if we injure people. Or corporations. Remember, corporations are people too, according to the Roberts Court. We also can be subject to injunctions, that is to say, a legal order from a court telling us to do something or to stop doing something. We also can use injunctions, legal orders from the court, to force people in government to do their jobs, such as providing a public record that we're entitled to. We're also subject to regulations by the Federal Communications Commission, the Federal Trade Commission. Of course, the FCC, important to us because of net neutrality. The FTC, if you're going to be in a business that does advertising, they have some harsh rules that you can run afoul of. So, having gone through the Judge Jameson hypothetical, let's talk about how laws work. Crimes, torts, and crimes. The state has said there are certain things we don't want people to do. They hurt society. And so the state says, don't do this. And if people engage in that activity, the state can punish them after a judicial proceeding. Now, in order to punish them, they have to have a conviction, and the two elements that prosecutors must prove are Actus Reus and mens rea. The Actus Reus, of course, the criminal act. And we'll see some Latin scattered through the course. Part of this is because if we didn't use Latin, then we wouldn't be able to charge you as many hundreds of dollars an hour that we charge you. It makes it a little more sophisticated, or at least sound that way. The mens rea is the criminal thought, and most crimes require that the defendant have a criminal intent to do the bad thing. There is an exception. The exception is for strict liability crimes. Strict liability crimes say that if you commit them, the state does not have to prove your mental intent to do so. The fact that you committed the act is enough. So good examples are overparking at the meter, parking in a no parking zone, or speeding. If they ticket you for parking in a no parking zone, you can't go to court and fight the ticket by saying, well, I didn't intend to park in a no parking zone. If you get a speeding ticket, you can't go to court and say, no, you can't find me guilty and fine me because I didn't intend to go fast. In fact, I didn't know how fast I was going. My speedometer's broken. So I was just driving down the highway as fast as everybody else. Doesn't work. Criminal procedure, of course, you know this from your civics course in public school. There's notice. People need to know what's illegal. Now, be careful, because this doesn't mean that you can commit an act which turns out to be a crime and claim that you can't be prosecuted because you didn't have notice of the crime. Notice is applied as a general principle. So, robbing banks. They don't send letters or emails to everybody that says, hey, robbing banks is illegal. Everybody knows robbing banks is illegal. So ignorance of the law does not excuse you. Second, the conduct that the state has criminalized, anything from speeding to murder. Third thing is, once you do the bad thing, according to the state, there's arrest, trial, and the appellate process. And after all of that, perhaps imprisonment. We won't deal with capital cases. We're not going to put you to death here. Now, you've seen TV, you've seen the courtroom dramas, you've gone to the movies, you may even have read a book, and you know that the state, the prosecutor, has to prove the elements of the crime beyond a reasonable doubt. And if you didn't do debate or mock trial in high school or college, a reasonable doubt can be kind of a nebulous concept. But at its most basic is that you've come to a conclusion, you, the finder of fact, perhaps the judge, perhaps the jury, about the innocence or guilt of the defendant, and that conclusion is based upon reasoning through the facts and having no doubts about that finding or conclusion. Yes, I've considered this, and beyond reasonable doubt, I think this person stole that car. Not because I had a gut feeling, not because I didn't like the way the defendant's shifty eyes moved about the courtroom. You looked, you applied reason, and came to your conclusion. Torts, on the other hand, civil wrongs, and they occur when one person or entity, can even be a corporation, causes harm to another person or entity. You should know that it's possible for one act to be both a crime and a tort. When we get into privacy and we talk about trespass, you'll understand that trespass is both a crime that you can be prosecuted for, and it's a tort that you can be sued for. So be careful out there. In civil cases, the standard for coming to a judgment is a preponderance of the credible evidence. People who've been in debate tend to say it's 50% plus one scintilla. Well, not everybody who's been in debate. I mean, people who are needle butts would say that. And that's not really 50% plus one scintilla. I mean, think about it. You have made decisions all your life. You pick one thing over another. you've never made a choice that was 50% plus 1 scintilla. It's always been more weight on one side than the other. And the same is true in jury verdicts in civil cases. No case has ever come down to 50% plus 1 scintilla. There's always been more for the winning side. And since we're talking about civil law, you may as well learn Professor Loving's Maxim of the civil law. I'll try not to refer to myself in the third person through the course. But my maxim of the civil law is this: any fool can sue any other fool over any fool thing. And you see examples all around you. If you ever went out to get a can of spray paint, you may have looked at the label, and on the label it says, "Do not point this at your eye and press down the button to see how all that paint comes out of that little tiny hole, because you'll spray paint or shellac your eye." And the reason they have that warning is because people have sued after they've done the fool thing and harmed themselves. You have to be careful. Well, since we have a lot of people suing a lot of people, the question comes up, are there too many lawsuits? And because this is a presidential cycle, you'll hear a lot of people talking about, too many lawsuits and how they need to be reined in. Well, let's talk about one. It's a famous one. You may even have heard about it. It's the McDonald's coffee suit. Hello? I'm doing fine. How are you? Good. That sounds great. Yes. Oh, it's going fine. Sure thing. Bye-bye, my love. Hey, sorry I couldn't take your call. I was recording a lecture for my summer class.
Do you have that yet?
Hang on, let me look. Did you send it to the Gmail?
Yes, I did. Or we sent the Gmail, the Calco 2 one, we sent it to the Professor 3 of them.
Okay. All right, hang on. Let me come out of this one program. The more or less final draft editorial? Is that the one?
Probably, yeah.
Okay, the Calcos news editorial.
And they wanted to make this much, the attorney wanted it very short, to the point. They don't want it to seem like Anatole and Ergo.
Right.
You know, they said, that's fine, but you don't want that, but you're doing the same thing back.
Okay. All right. It's the same thing I saw before. I didn't have any heartburn with it before. So I think we're good.
Okay, good. Yeah, it's just, Andrew wrote it, you might take a quick sketch, he rewrote it in here, a little bit different wording, but I think it's still about the same.
Yeah. The only thing I would say is...
I haven't gotten approval from, I don't have approval from the LA attorney yet.
Okay.
So I'm still waiting on them.
Okay. Good deal. All right. Yeah, ship it off to them.
Okay, what I would say, I get a tendency from a lady who is like I can't remember, she's got a PhD in some type of psychiatry
Okay.
And she wrote an opinion piece about our close news. I don't think I've ever even spoken to this woman.
Oh.
I might have talked to her once somewhere. Someone told me she had some information that would be good for me, but right now with lawsuits and stuff, I'm kind of not getting what I mean.
Yes.
But anyway, she put an opinion piece together about Calco's news and the assault on Calco's news, more from someone that looks at people's behavior, and I think she got her BA or something in journalism, and then went to get her doctorate, and they got a master's and a doctorate. And it's kind of a personal, it's kind of personal.
Yes.
The headline was awful, but it's a little, it's about, she said, I looked through the characters, I found this, I found that, I found this, I found that. I went through all the allegations that you've done in the police department, and, dozens of articles. This is what I have determined, and it appears to me that they don't know she, or 7 days ago, no, she was from people that are harassing her or doing it for this reason, that reason.
Okay.
And it's just kind of, I'm going to email it to you, the headline form.
Okay.
I would never put it up with that headline, but just tell me what you think, and also, if there's nothing has to be cleaned up in that.
Yeah. And you have vetted this woman, right? You know who she is. She's a real person. She's not somebody that...
Yeah.
Okay.
No, I know exactly who she is.
Okay.
She thinks that the board of supervisors is very political. She was Democrat. She was actually, I think she probably supported Adam. She's not a Republican or anything doing this for political reasons. She doesn't like political entities. She is political.
Okay.
But I will email it over to you, and again, the headline says, she's searching for characters.
All right. I will look at that.
Okay, thanks.
Uh-huh. Bye. And here we have the McDonald's coffee suit. Case is styled Liebeck versus McDonald's. The injury occurred back in 1992 in February. Ms. Liebeck, 79 at the time, was riding in a car that was driven by her grandson. They went through a McDonald's drive-thru. Now, the story you may have heard about through social media or people who are just shooting the breeze is that some woman went to McDonald's, got a cup of coffee, was driving along, took the top off as she was driving and spilled coffee on herself and sued McDonald's for thousands and thousands of dollars. Well, there is a kernel of truth, but not much more. So here we are. She's in the car. She's a passenger. After leaving the drive-thru, her grandson stopped the car so she could put cream and sugar in the cup. She put the cup between her thighs to be able to pull the lid off. If you drunk a lot of coffee from fast food places, you'll know that sometimes the lids come off pretty easily, but a lot of times they are difficult to get off. But she pulls off the lid, the coffee spills, and she suffers third-degree burns in her lap. The burns covered 6% of her skin. Now, third degree is the most serious kind of burn you can get. Here we're talking about the destruction of tissue. She was in the hospital for a week. She had to do skin grafts. And skin grafts are where they pull off the dead skin, and then they take a device and they slide it along a part of your body where the skin hasn't been damaged, and pretty much they just, like turf, they cut underneath the skin, lift it up, and then they lay that skin on top of the part of your body where the tissue was destroyed. It is not a fun procedure. After she got out of the hospital and was better, she went to McDonald's and said, look, I was burned because of your coffee, and it cost me $20,000 to go in the hospital and take care of my medical expenses. McDonald said, well, you know, whatever, we'll give you $800 and then you can go away. Because McDonald's did not agree to pay her medical, she sued. And let's talk about the process of the civil suit. First, we have the injury. We've covered that. And then we have the beginning of the lawsuit. Now, before a lawsuit is commenced, the parties, the so-called victim, may approach the defendant, the person who caused the injury, to say, look, let's settle this. Give me some money. I'll be satisfied. When it doesn't work out, as it didn't work out between Ms. Liebeck and McDonald's, they went to the lawsuit. So the first thing that happens is Ms. Liebeck, the plaintiff, goes to a lawyer. The lawyer writes a complaint. There's also a service of process. In Ms. Liebeck's complaint, she said she was injured because McDonald's coffee was inherently dangerous because of the temperature. You don't get third-degree burns from lukewarm stuff. Then, once McDonald's has been notified of the lawsuit, the service of process is where you let the defendant know that the defendant's being sued. The defendant will answer. And McDonald's said in its answer that it had no liability because, hey, everybody knows coffee is hot. If you spill it on yourself knowing the coffee is hot, well, that's your lookout. McDonald's denies the claim. Then we move into discovery. Discovery exists so that we don't play trial by ambush or trial by surprise. Even those of you whose grandparents watch Matlock, there is no surprise witness who comes in during the trial to surprise the really bad guy and force the case to be won by Mr. Matlock. In discovery, we get information that the other side has so that we can prepare for an even contest in the courtroom. Discovery covers a number of things. One is admissions. One party will send a list of admissions to the other. Do you admit that your name is Miss Liebeck? Do you admit that you're 79? Do you admit that you went to McDonald's on so-and-so day? And Miss Liebeck's lawyers would have, do you admit that you are McDonald's, a corporation? Do you admit that you have a restaurant at so-and-so location? Interrogatories, this is where the attorneys for each side get to ask questions of the other side. Ms. Liebeck's lawyers could ask McDonald's how many times people had complained about getting burned by the hot coffee. And McDonald's lawyers could ask Ms. Liebeck how many times she'd sued people. We have requests for production. That is to say, the other side has to produce things. Now, McDonald's required Ms. Liebeck to produce her medical record so they could see what happened to her, to make sure that it wasn't from an unrelated injury. And Ms. Liebeck could request that McDonald's produce its coffee machine so that she and her experts could then test it and see what was going on there. Then we have depositions. Depositions are sworn testimony that are made before trial, but which are admissible as evidence as if it was delivered in the courtroom. Now, in discovery, McDonald's said that it had about 700 complaints in the decade before Ms. Liebeck was injured. Then, having gone through discovery, each side knows all the facts as best they can tell. They go to trial. At the trial, you have opening statements by both sides. In the opening statements, the lawyers will say, here's what I'm going to prove, here's why the other side is wrong, here's why you, the members of the jury, should vote for me when it comes time to deliver the verdict. The plaintiff gets to put her case on first because she has the burden of proof. So Ms. Liebeck gets her witnesses. Her lawyer gets to ask questions of her witnesses. Then the lawyer for McDonald gets to do cross-examination, that is to say they can ask questions about the same things that her lawyer asked about in an attempt to discredit the witness or to clarify what the witness said or to show that the witness helps the other side win the case. All evidence comes from the witness box. And without having been produced through the witness box, it doesn't get to end the trial, and it should not affect the jury's decision. There may be a lot of things that people know, but unless a witness is able to show that the evidence is credible and reliable, the jury doesn't get to hear it. Once the plaintiff has put on her case, these are all the facts, these are all the witnesses, the plaintiff will rest, and then the defendant can put on a defense. The defendant does not have to put on a defense. If the defendant says, oh, your case is so weak, I don't even have to put any witnesses up, the defense can do that. Doesn't happen very often. So McDonald's, of course, put on a defense. In her case in chief, in her side of the trial, Ms. Liebeck testified about the spill and how she was injured. She brought in experts who testified that liquids at 180 degrees would cause third-degree burns in as little as 2 seconds. Her experts also testified that most restaurants served coffee at a lower temperature, and the coffee that people make at home averaged 135 to 140 degrees. A whole lot of difference from 180. 180, incidentally, was the temperature of the coffee at McDonald's. In fact, McDonald's said that it held its coffee between 180 and 190, and it did so to provide the best taste. But McDonald's quality assurance manager also said that the coffee was so hot that you couldn't drink it when it was poured. And that's true. I worked for McDonald's when I was much younger, and people would order the coffee and they would ask for a cup of ice, and if they were going to drink the coffee right then and there in the restaurant, they would put ice in the coffee to bring it down to a drinkable temperature. Now, when McDonald's put on its case, it presented evidence that customers knew that the coffee was hot. And McDonald's said that its research showed that customers bought the coffee to take to work so they could drink it at work or take it home so they could drink it there. Therefore, by the time they got to work or got home, it would have cooled down to a drinkable temperature. But on cross-examination, McDonald's witness said, yes, most customers drink the coffee as soon as they buy it, usually while driving. And on cross-examination, the quality assurance expert for McDonald's said that he had not checked into the safety of coffee when it was sold at a temperature of 180 degrees. Well, McDonald's put on its case, the plaintiffs that put on her case, the defendant put on his case, both sides make closing arguments, and then they have a deliberation form that defines the legal question. At the close, Ms. Liebeck's lawyer said, look, McDonald's sells coffee at this unsafe temperature. It poses a risk to all customers, and it caused Ms. Liebeck's third-degree burns. McDonald's, in its close, said that, hey, people know the coffee is hot, and if they're not careful, well, that's their own responsibility. The finder of the facts after these closing arguments, and once it has received the deliberation form, will then retire. The jury goes into the jury room, they deliberate, they consider the evidence, and they come to a conclusion. Which brings us to the judgment. That's rendered by the finder of fact. Not finder or fact, finder of fact. In the Liebeck case, the jury said Ms. Liebeck wins. They awarded her $200,000, but the jury said she was partly responsible. In fact, she was responsible 20% for her injuries, so they reduced the award to $160,000. That's what they awarded her for her actual injuries. That's what they thought would compensate her, to put her back into the position she occupied before the injury. And that's fine. But there also is something called punitive damages. And the jury awarded her $2.7 million in punitives. It was reduced by the court to $480,000. Punitive damages are damages intended to punish. We're going to punish McDonald's. We're going to take $2 million away from it. And the punishment is to deter McDonald's from selling coffee that hot ever again. Then we have the appeals. The losing party gets to appeal. The winner doesn't get to appeal. You say, well, I should have won more. No, you don't get to appeal. It's just the loser. And appeals are generally based upon questions about evidence, whether it was improperly admitted or improperly excluded. McDonald's appealed, but it settled the case for an undisclosed amount. And it made the settlement subject to a confidentiality agreement, so it was not generally known. If McDonald's hadn't settled, the appeal would have gone to a higher court. At the appeal, the appellate court looks at the record. It doesn't retry the case, doesn't hear from witnesses, but it reviews what was said in the trial, especially the judge's ruling as to evidence. If the judge made an error, the appellate court decides that the error was harmless, that is to say it did not change the outcome, or that the error changed the outcome of the case and therefore was a reversible error. If the appellate court judges say, yes, the judge made a big mistake and that mistake changed the outcome of the trial, they can overturn the judgment and send the case back. The losing side in the appeal can appeal to the next higher appeals court until you run out. Of course, the highest court in the United States is the Supreme Court. It doesn't take every case. The cases it takes must implicate a constitutional issue. And so a personal injury suit like Ms. Liebeck's would not get to the Supreme Court. Now, our cases, most, if not all of our cases, could or did get to the Supreme Court. And in our cases, the appellate court doesn't look so much at evidence, but rather whether or not the trial court judge properly applied the First Amendment or not. And if the judge didn't properly apply the First Amendment, well, that's a reversible error and the case can be sent back down for a second trial. We're going to hold on right here. Tomorrow there'll be a new video, but I think this is enough to keep you busy for a while. We'll see you soon. Bye.